Hi, John. How are you doing?
I'm good, Jason. How are you, my friend?
It's always good to see you. Today, I want to talk a little bit about OUI drugs. We're seeing that being charged more often, and it can be a tricky type of case to deal with.
Absolutely, and you're correct. We do see that quite often, and there's a whole host of issues, um, really, in prosecuting those cases. I find those a little bit easier to defend than our OUI alcohol brethren. So, um, very excited to talk about this issue today with you.
Yeah, so I definitely want to siphon it out, and let's do another video regarding actual OUI or marijuana, and all those issues connected to that. But let's talk about, the drugs that we may see in terms of like fentanyl, heroin, cocaine, those different classes of drugs, or it could be some type of opiates. Um,
Right.
I guess like right off the bat, the difficult thing is because we don't really have a breathalyzer. A lot of times when they can actually figure out the amount in someone's body is through a blood draw. But without that, they don't really know if what's in their system.
Right. And first and foremost, you just touched on a very interesting issue about no breathalyzer. From our prior videos, we know that the breathalyzer is the almighty deciding factor in terms of a license suspension. So when you don't have that opportunity in an OUI drug situation, it's all or nothing, and that's completely up to the police department. So often the police will put in for what's called an immediate threat suspension, which
Correct.
is awful. That is an indefinite suspension, and we can't do anything with that until the case is resolved in court. The registry will not issue any type of hardship nor restore the license until the case is closed in court. Um,
Right.
However, I do have a lot of clients somehow that overdose or are under the influence of a narcotic who don't get their license taken away. So there's a serious flaw there. The other issue oftentimes is that these people aren't arrested. They are sent to the hospital. And that's to your point about medical records, blood draw, in
Right.
terms of what concentration of a narcotic or an illicit substance is in a person's system. But the police oftentimes will just cite them, give them a citation. And then again, we go back to what we talked about a couple weeks ago. That person is smart enough or coherent enough, they're going to appeal, right, and
Right.
file for a magistrate's hearing. And now that opens the door for me to get creative in terms of how I can try to resolve the case through a magistrate's hearing and keep it out of court altogether.
Yeah. So I mean, I think so. Let's go back to the immediate threat. I think people have to understand that immediate threat, if served on you, which is generally they'll come to your house, serve you with the immediate threat in hand, tell you
Yep.
that you no longer can drive. We not only can we not do anything with that immediate threat until your case is resolved. Now, obviously, you can go to the R&V if you want, but they're not going to reinstate it.
No.
The other thing is the immediate threat doesn't come off as a result of the end of the case. You still have to go through
No.
the R&V process for that. So that's very important for people to know.
Right.
And the other thing about OUI drugs, context is everything. What's in the car, what was said, and the whole actions even before you get to the hospital is everything. So, I mean, I think we saw a lot of cases in terms of, omitting, statements that were made to the police. If the EMT came and the EMT made certain observations, if they used Narcan on the individual, what other things
Right.
were found inside the car in terms of if there's actual narcotics found in the car, on the person, where is the person coming from. So context in these cases are very important because not only sometimes you see there's some erratic operations, sometimes you see that the person might be passed out on the side of the road and need to essentially be Narcan back to life. But the context of all that is very important in terms of actually trying to prove the underlying case.
Right. So from a prosecutor's standpoint, this becomes more of a totality of the circumstances, right, in terms of trying to prove it, because you have to take into account everything that you've just discussed. Now, with an OUI alcohol, there's other evidence that they're going to use or try to use, and that involves obviously a breath test if it's admissible and used, but field sobriety tests, right? The field
Correct.
sobriety tests that the police are trained on are specific to alcohol impairment, not drug impairment,
Right.
and that's a specific defense for us because when you're trying a case to a jury or even a judge, the common layperson does not know how heroin, cocaine, opiates, how they are going to affect the body and affect us in our cognitive ability to function. Whereas alcohol is more common and it's more publicly accepted. And so people can relate to how alcohol makes them feel. And they're allowed to use that when rendering their verdict. Can't do that with drugs because not everybody can relate to that. That's not common knowledge of a common layperson. And so that becomes really the crux of our defense in those cases.
Right. And then you can move into the whole idea of, do they need to use a drug recognition expert? Do they need to bring an expert whatsoever? Now, the law doesn't require them to bring in any type of expert, which is going to cost the government money. But that becomes a problem when they're testifying to the point where it's information that really should be where an expert should be testifying about. So they may try to kind of backdoor in some of that evidence. And I think it's at least a little bit easier with a narcotics case or like an opiate case versus like marijuana, which is certainly a different topic. And there's just so much to talk about and break down in terms of marijuana itself. But I think it's at least a little bit more conceivable that a judge would say, well, where a person has OD'd, where an officer is trained with Narcan, or if they have an EMT testify, I think that might be a little bit closer.
Right, because in the end, the charges are the same, right? The elements of the crimes of OUI alcohol and OUI drugs are the same. It's just that third element is what is causing the impairment. So in the alcohol cases, do you have a blood alcohol concentration of 0.08% or greater? Or has the alcohol you consumed impaired your ability to operate safely? With drugs, we don't have a specific limit. It's just whether or not the drug consumed impaired that person's ability to operate a vehicle safely. That's so obviously, if we have a case where somebody is dead at the wheel, they're overdosed, safe to say that's probably they couldn't operate a vehicle safely at that point, right? And the crazy part about it, like I've said, is that if those people are able to apply for a magistrate's hearing, a lot of what you and I do is helping these folks get treatment and get clean and get sober. And so, if that hearing's not for 4 months and now our clients got 4 months of sobriety under their belt, they're doing counseling, they're doing testing, they're doing what they should, a lot of clerks they're not going to want to punish them, and it really comes down to the police. The police have to be on board with that in a magistrate's hearing. And by and large, they are. People want to see people get healthy and get well. And so they know that issuing this complaint is going to set this person back potentially. I oftentimes ask them to just hold it open for another year and allow my client to prove to the court and to the police that they're serious about getting clean. They're committed to the sobriety. And, by and large, everyone has followed through with that because the threat of having that hang over their head and potentially be issued is enough to, keep them on the straight and narrow. Now, the side effect of that is the registry is still going to consider that open until the magistrate's hearing is closed, but that's the price of doing business. If you can't drive for a year, that's probably for everyone's benefit, quite frankly. And so the registry is going to require proof of sobriety. That's something that a hearings officer is never going to give back. So we ultimately always have to appeal that to the registry's Board of Appeals. But they're going to want proof of sobriety, 3 months of clean urine screens, letter from a doctor, affidavit from a doctor that the client is fit to drive. And so the registry has the ultimate power. Like I said in the beginning of this conversation, that's indefinite, that suspension. There is no set time period, not like alcohol where it's 180 days or 30 days. This is indefinite. So they have all the juice in that situation, and we have to do what we can to try to undo it.
And I think it's important that we talked about context matters, right? And context not only matters in terms of the charges itself, but also during a clerk's magistrate hearing. If there's any aggravating factors, they are going to issue that. If someone,
right.
If there was a car accident,
you absolutely. Right. If there's an accident, if somebody was hurt, we have no shot, right? But if it's your run of the mill, unfortunately, and I see it a lot where people are overdosed, they're usually just in the middle of the road, stopped, and somehow with their foot on the brake and the car not moving, the car doesn't drive. It blows my mind every time. Unfortunately, the police act quickly. They put the car in park. They shut it off. They get, they Narcan. EMTs are great, especially in New Bedford. I mean, I just see it so much, but we want to get people healthy, and so we take that opportunity, and by and large, we're doing it. So it's just a, different way of going about it, but they're still paying a price, right? I mean, they're still having that sanction of not having your license is tough, right? I mean, it's tough not to have a license for a long period of time.
So we talked about in terms of how a case starts. We also talked about essentially how a case develops. We broke down some things in between, but I think it's also important to kind of touch upon how cases end, right? That the statutes regarding the drug statute, the OUI drugs versus the OUI alcohol statute, is not as developed. So what that means is the programs that are statutorily connected to an OUI alcohol case are pretty much used in a lot of the drug cases too, which doesn't make a ton of sense. There is no a real first offender drug program for them to go to.
No.
So
same thing. It's the same program.
Right. Which is interesting because they just really haven't really thought about it. They really haven't thought about it in terms of creating something that's close to a breathalyzer for drugs. They really haven't had their own separate statute in terms of license suspension and what situations with that. And it's really all based on the alcohol statute, which is very interesting. They haven't carved out anything new for that.
No, and I think the difference is with Massachusetts, defendants are afforded more rights than even the U.S. Constitution, right? So the Massachusetts Declaration of Rights provides our clients with further protection, and so unlike other states, there's no, you have the right to refuse, and that can't be used against you in court. Whereas that's a crime. So in Rhode Island, that's a crime, right? And right next door is a crime to refuse a chemical test. Here, they just can't use it against you in court. So, it's very state specific. Massachusetts is one of the, more defendant protected states in the United States. So it's important to know that and know what your rights are and know how to defend them.
That's right. Well, John, thanks for coming on and talk about marijuana next time.
Sounds good, Jay. Good to see you, buddy.